What is the legal difference between duty to defend and duty to indemnify? Imagine signing a contract and suddenly facing a legal claim. Do you know who is responsible for defending you and who will pay for damages? These questions are at the heart of understanding the difference between the duty to defend and the duty to indemnify. They often appear in indemnification clauses, which are common in business and contractual agreements. Getting these terms mixed up can lead to costly legal mistakes. So, let's break down what each duty really means and how they differ. The duty to defend is about providing a legal shield. If a third party makes a claim against you that falls under the contract, the other party must step in and cover the costs of hiring lawyers to defend you. This happens right when the claim is made, even if you are not yet found liable. It is a broad obligation that can include defending questionable or even weak claims. Think of it as a proactive shield that kicks in early to protect your interests. On the other hand, the duty to indemnify is about paying for damages or losses after liability is established. Once it is proven that you are responsible or at fault, the other party must compensate you for the damages covered by the contract. Indemnification is about reimbursement for actual losses, not about fighting the claim itself. It is a reactive obligation that only applies after liability is confirmed. The key difference lies in timing and scope. The duty to defend starts early and covers legal costs for defending claims, regardless of fault. The duty to indemnify kicks in later, covering damages once responsibility is clear. The defense duty is broader because it can include defending even weak or questionable claims, while indemnification is narrower, limited to actual damages or losses. Many contracts make mistakes by mixing these duties or not defining them clearly. For example, some contracts say the same thing about both duties, which can cause confusion and disputes. To avoid this, it's best to clearly specify in the contract what each duty covers, when it applies, and how claims are handled. For instance, specify who controls the defense, what types of claims trigger each duty, and whether there are limits on indemnity payments. Another common mistake is not including procedures for notice or how to select defense counsel. Without clear rules, disputes can delay or complicate the process. Also, some clauses only cover third-party claims and forget to address direct claims between the contracting parties. Clarifying whether direct claims are included helps prevent surprises. Balancing the obligations is also important. Agreeing to indemnify the other party without limits or protections can expose your business to excessive risk. Including caps or exclusions can help manage potential liabilities. Plus, requiring the other party to maintain insurance can ensure they can meet their defense and indemnity obligations. When drafting or negotiating contracts, always keep these points in mind. Clearly separate the duty to defend from the duty to indemnify. Define what claims are covered, how and when each duty is triggered, and the procedures involved. This clarity helps prevent misunderstandings and reduces the chance of costly legal fights. By paying attention to these details, you can protect your business and make sure everyone understands their responsibilities.